So what really happens at your 341 bankruptcy meeting? Today we have Luke Homen, one of the top bankruptcy attorneys in Oklahoma, sharing this insight. Luke, what happens in a 341? And well, first of all, let's start with high-level overview. What is a 341 meeting, and then what happens?
Sure. All right. There's a section of the bankruptcy code. Everything in bankruptcy is almost always just based on a section of the bankruptcy code. And section number 341 is a section that talks about a meeting of the creditors. So we call it the 341 meeting of the creditors because it comes from section 341 of the bankruptcy code. It's not a court appearance.
I didn't know that.
We usually call it a court appearance.
That's good to know.
To describe it. Yeah. But what is it really? It is a meeting of the creditors. And historically, this could take place in a room next to the courthouse. It could take place in a basement. It could take place anywhere that the U.S. Trustee program rented a room.
Mhm.
Nowadays, it's on Zoom.
Makes it easy.
Sure does.
Yeah. And okay, so meeting of the creditors, does that mean the creditors? So if I'm filing bankruptcy and I have a list of, I have 20 loans or whatever that are going to be discharged and putting into bankruptcy, do all these creditors come to this meeting and like negotiate, or what like?
So let's break it down into
Yeah.
different chapters of bankruptcy first.
Perfect.
In a chapter 11, like let's think of General Motors or Toys R Us. Yeah, that's probably happening. You've probably got these multi-million-dollar lenders with multi-millions at stake, and they send all their high-powered attorneys. Chapter 7, no. The creditors have the right to appear, and sometimes they do, and we'll talk about common reasons why they do, but they don't because it's not worth their time. There's a bankruptcy trustee that's already watching over the process, and this is not General Motors. This is Jack and Jill, and they lost their job. It's
Yeah.
not worth Chase sending an attorney.
Okay, so and what about in a 13? Is it any different with a 13? So primarily what our clients are watching this for, these are people in debt, they lost a job,
Right.
got in a car accident. They're either going to do a chapter 7 or a chapter 13 or maybe a subchapter 5. So even at 13, the creditors aren't showing up.
13, it's more common that a secured creditor shows up because in chapter 13, you're usually adjusting or doing something with secured debts. You're paying them, you're not paying them. And so it's more frequent that a secured creditor might send an attorney. Maybe they asked one or two questions, or maybe they just have a conversation with the chapter 13 trustee. Uh, More common. And that's not to say, why did you get this debt? It's usually more like, well, we want 10% interest and you want 4% interest. So let's talk about interest rates.
Got it. So
That doesn't
secure and
happen that
secured.
often, but it can happen at 13 more than a 7.
Okay. So secured creditors, these are like homes, cars, that type of thing, right?
Exactly. Yeah.
Okay.
Sometimes furniture, sometimes, you went down to a place and bought, a love seat.
Okay, got it. So it's really it's a negotiating chapter 13, what interest rates can be paid. Is it ever negotiated, like what percentage of the debt's gonna be paid?
Yes.
Okay, so it can be either way.
Oh,
So there's 2 levers there.
yeah. That needs to be a whole different video. But
Okay,
in chapter
okay.
13, sometimes secured creditors participate, but unsecureds, it's very rare. And then in a chapter 7 meeting of the creditors, usually when a secured creditor shows up, it's a car lender just wanting to know if you still have car insurance. They might say, did you still want to keep this car? Does it still have insurance?
Mhm.
That's all the questions I have.
Got it.
That's usually what happens because they just want to know, is their car protected?
Yeah.
And they can't call you directly anymore because now you got an attorney. So the easiest way for them to figure this out is sometimes they show up at the 341 and just ask, hey, do you still have car insurance? Oh, who's that with? Is it full coverage? Okay, no more questions.
Got it. Okay, so going back to what happens in the 341 meeting, at the end of every bankruptcy, chapter 7, we're only gonna focus on 7 and 13s. Chapter 7 and 13s, you're starting the process, and then there's this 341 meeting that's named after the bankruptcy code, paragraph 341, right?
Yes. Now, this usually occurs about a month after you file your bankruptcy. I think it's 28 to 45 days. It depends on the court calendar. And usually the court clerk just sets this and nobody has any control over when it's going to happen. So it's about 30 days after you file the case. And it's this Zoom meeting. For
And they have a Zoom
us,
meeting, right?
for us, Chapter 13 meetings are usually an hour long because they get through more cases. Chapter 7 dockets are usually 30 minutes long, but that's 30 minutes or 1 hour to get through a whole batch of cases.
Okay.
So
So
here's
when you say a batch, meaning there could
6,
be
7, 12.
okay, many other people
Right.
in the 341, but I'm assuming it's all private. Like you can't see who else is on the 341, right?
It depends on the trustee.
Yeah.
Some trustees have an open meeting where you could see everybody's name because you got to think back in the old days, everybody was sitting together in the basement or everybody was sitting together in this room next to the courtroom. And so, you don't have the general public walking through, but there's other bankruptcy attorneys that are probably going to be in the room. And there's other people who also filed for bankruptcy and happen to be on that docket with you. Now, some trustees create a private room for each individual. I think that's pretty rare because you got to click a lot of clicks in Zoom, but it's semi-private. So let me just kind of break down how the meeting goes.
Yeah.
The first thing that happens is the trustee comes on, turns on his video, you or her, him or her, right around this time the meeting's supposed to start. And they usually start with some general announcements, something like, "Hello, my name's Phil. I'm a bankruptcy trustee. Here's how the hearing is going to go." And they're going to give you some general thoughts. Every trustee is going to have a different way of saying this. Some trustees, it's one or two sentences. There's a Chapter 13 trustee I know who, in the old days, used to get up and give like a 20-minute speech. That's not common anymore on Zoom, but the trustee is running their hearing. And so they'll start with a preamble, a little speech, and then they're going to start calling cases. And they'll say, okay, the first case that we have today is the bankruptcy of Jack and Jill, case number 25-90111. All right, debtor attorney on this case is Bob. Bob, are you here? And then Bob will say, yeah, I'm Bob. And then the trust will say, Jack and Jill, are you here? And we'll get them unmuted. We'll get their video turned on. And they'll say, yeah, we're here. The next thing's going to happen is the trustee's going to swear them in to tell the truth. All right, Jack, Jill, do you swear to tell the truth and all the truth, nothing but the truth? Yes. Because you got to keep in mind, all this testimony is under oath. Got to tell the truth. Okay. Now the trustee has pre-scripted questions. The Department of Justice, and you can even Google this, the Department of Justice has mandatory questions the trustee has to ask every single debtor.
So you know what questions are going to be asked.
Right. Now,
Oh,
each trustee is going to word these a little
okay.
differently. They might be a little more folksy, they might be a little more formal,
Right.
but it's the same questions. And let me just kind of run down some of them for you. All right. Have you ever filed for bankruptcy before? If yes, was it in the last 8 years? Do you owe anyone a domestic support obligation? Did you sign your bankruptcy
Now, domestic support is like child, like
house or alimony?
oh,
Yeah.
okay.
Did you sign your bankruptcy petition, schedule, statements, and related documents? Did you read them before you signed them? Do you have personal knowledge of everything you submitted? Are the documents and the tax return that you provided true and accurate copies? Did you list all your assets? Did you list all your debts? Do you have any errors or omissions in your bankruptcy petition that now you need to reveal because you made a mistake? Did you review the bankruptcy information sheet? This is a one-page handout that your attorney will give you on how bankruptcy works. It's not hard, you just got to read it.
Mhm.
Did you review the bankruptcy information sheet? You expect an inheritance the next 6 months. Is the address on the petition your current address? Because they might need to mail you something. Do you own any real estate or minerals? Do you have a reason to sue somebody? And then usually the very last question they ask you, the only one that's not a yes or no, is usually, why are you filing bankruptcy? And they don't need your life story. What the trustee is trying to figure out is, does this all make sense? Yeah. I lost my job. I got garnished. We got medical debt. I got a car accident. My car got repossessed. It's 2 or 3 words.
Yeah.
But what if you say, all right, well, I'm in this massive lawsuit and I've got the right to get $600,000 against Joey, but I can't pursue that lawsuit anymore because I got hit by a bus. And now the trustee's like, oh, okay, tell me more about this lawsuit against
Lawsuit.
because maybe that's something I can make money off of.
Yeah.
Because the trustee's doing 2 things here in this meeting. Number 1, they're asking all the required questions. But number 2, they're trying to see, is there anything about your case that doesn't make sense or anything about your case? I guess that's 3 things. Anything about your case where there's money for the creditors. That lawsuit against Joey, that Corvette that you have that you don't drive, classic car from the 1920s. Sometimes people have these things. They don't need them. If they sold them, it still wouldn't pay off all their debts. but it's something they don't need for their reorganization. And so the trustee might ask some questions about that. Maybe one or two questions.
So the trustee is basically this third party individual who's looking out for the creditor's interest and the debtor's interest or the client's interest and making sure that
And the
everything's legit and making sure there's no
terms of
abuse,
justice.
right? Making sure there's no abuse.
Is there anything wonky going on here, right? Usually the answer is no. Almost always the answer is no. But sometimes things don't line up. And that's why they ask these questions. That's why they ask the why, because they want to find out, does it make sense that this person's filed bankruptcy? Or is something missing? Is something being hidden or lied about? Um, that's what the trustee's also trying to figure out behind the scenes is this guy lying to me?
Now, when you have a bankruptcy client and you're getting ready for your 341, you basically probably send them a one sheet or explain, hey, here's what a 341 is. Don't worry about this. Is all this correct? Like you review the questions ahead.
Here's usually the hardest part of the 341.
Yeah.
The hardest part is getting logged into Zoom. I'm serious. If you can log into Zoom, you'll take care of the rest just fine.
Yeah.
So we've got actually, it's like a two-sided piece of paper. One side is how to log into your Zoom meeting, and the other side is these are the questions you're going to get. And then we call the client beforehand. We practice the questions one more time.
Yeah.
Make sure they get signed into Zoom, and then we're on the Zoom call with the client.
And how long is the 341 with the individual client? Like for them, not for the 30-minute session, but how long are they talking to the bankruptcy trustee?
Yeah. So for us in Oklahoma, we get 6 cases every 30 minutes on the Chapter 7s. And on the Chapter 13s, it's something like 12 cases every hour. So when you also think the trustee is going to do a preamble for a little while, the trustee might need a drink of water because they're a person too. Each debtor usually talks for about 3 or 4 minutes. And that's it.
That's it. One last question, because this is a good summary. I've always been curious on what actually happens.
Yeah.
Out of all the thousands of 341 meetings that you've been in personally or you've observed, like thousands and thousands,
Yeah.
how many gotcha moments have you had where the attorney, they're going through these list of questions? I'm not talking your clients, I'm talking any client. Like, when someone just wasn't prepared, this is why the bankruptcy
Okay.
study is so important, right?
Yeah.
Like,
So
the bankruptcy I just wanna say one thing, Luke. The bankruptcy attorney is so critical because people get their cases dismissed because of the wrong bankruptcy attorney,
yeah.
right?
So when you do your petition correct, because your petition's like 70 pages, and then you submit all your tax returns and your bank statements and everything. If your attorney has done a good job, there's not going to be a gotcha moment because you've already disclosed your entire situation. And when you fully disclose your entire situation, you tell the truth about everything, there can't be a gotcha. The only time there's a gotcha is that one time that my client lied to me and hid something from me. But then the trustee finds it. Now we've got a gotcha. That's rare, very rare. As long as you don't lie to your bankruptcy attorney and you tell them the whole truth, you're not going to get a gotcha moment. You're going to be just fine. This isn't Perry Mason.
So there's, I'm reflecting on two things. One, there's a pro se filing where people file themselves. They're not bankruptcy
It can't be
attorneys.
done.
They don't necessarily know what they're doing. The level of dismisses of the pro se filers are through the roof. Like,
Right, it's so much higher. So in a Chapter 13, your failure rate as a pro se is over 99%.
yeah.
If you just, as a pro se, you're never going to complete. I'm sorry, you're just not. Chapter 13s are so technical and complex, you're just never, ever going to get, it's above 99%, the failure rate. Chapter 7, I don't know the stat, but I know the failure rate is substantially, substantially higher than if you have an attorney.
I mean,
Great to walk you through it.
if the success rate on a chapter 7 with a good attorney has got to be 99.9%. Like, it's
99.9%.
it's off the chart.
You hire a good attorney and you tell the truth,
Yeah.
99.9%.
So what happens in the 341 meeting is not a lot of drama. It's really simple. A bunch of set questions. You're on for a little bit. And one last thing, if it was a public Zoom and everyone's looking at each other, at that point, no one really cared. Like, no one's paying attention, right? Like, it's not oh my gosh, take a look who's on the Zoom. Like,
No,
yeah,
you're just saying, Yeah, I filed for bankruptcy. I told
Look
the
at
truth.
all of them did.
A list of all my assets. Everybody here filed for bankruptcy. And look, there's a whole room of us. You know, this
And
is horrible.
and by the way, there's a good chance that the debtor attorney filed bankruptcy, right?
Right.
If you understand how bankruptcy works, it's a lifeline for people who've lost a job, got in a car accident, medical debt, something like that. And the amount of people that abuse the bankruptcy code is so, so small. But that's why you have the trustees. That's why you have the 341 meeting.
And that's why you have a good bankruptcy attorney.
Yeah, there you go.
And tell them the truth.
Yeah, tell the truth. That's the most important thing. Luke, thank you for your time. As always, appreciate you.
Absolutely.